Judicial elections. They're routine in the U.S., but virtually unheard of in the rest of the world. Now the Supreme Court tackles how U.S. judges will be elected in the future.
So it's a very curious thing to say you're going to have an independent judiciary, but at the same time one accountable to the electorate.
Supreme Court correspondent Adam Liptak on Williams-Yulee v. the Florida Bar, now on the New York Times Minute. The specific question at issue is whether judges can personally solicit campaign money.
The question is, how closely tied is the judge to that money? Whether the judge can personally say to somebody, please help me get elected, and whether that does damage to the integrity of the judicial system.
Those arguing for a ban on judicial fundraising believe it would stop corruption.
The more judicial campaigns look like general political campaigns, the more some people think people are not getting a fair hearing, but one influenced by the money involved in electing judges.
On the other side, the lawyers for the woman who brought the case argue that barring fundraising speeches and mass fundraising mailings censors free speech. The argument is that
if you're going to have elections, the First Amendment plays a role, and the First Amendment has to allow judges to campaign in a way that their messages are heard. So it's a clash between these two values, the free speech value on the one hand and judicial independence and integrity on the other.
With a decision expected by summer, the larger question is what a judge's role really is. Are they detached from politics and marked by their technical skills, or are they just like any other elected official? For now, many signs point to a ruling that may further loosen campaign restrictions.
That's been the trend among federal courts looking at these issues, and it will make judicial elections look more like any other elections.